Alex here with a high conflict child custody video on criminal charges. It might sound weird. You might think, why isn't this in the criminal playlist? This is starting to happen a little bit more in these child custody cases, and so I decided to do a video on it. Back when I was representing myself in 2008, this was pretty unheard of. Most of the people who were dealing with exes that were committing crimes, it was not that they were being charged for them. They would just, say, hey, family court judge, here's all the crimes they're committing. And the family court judge wouldn't do anything about it because they really couldn't. Those had to be prosecuted by the state. But here we are in 2023, and I'm seeing this come up more and more. There's custody cases going on with criminal charges pending against one of the parents. I kind of have a lot to say about it. I guess it'll help. I don't know for sure. I mean, this is going to be a video with a lot of opinions and not a whole lot that you can do if your ex is the one that is charged. If you're the one that is charged, there is a lot you can do, and that is invoke a right to a speedy trial and get through your trial as quick as possible. So there's complaints from both sides on this. The complaints from the parent who's dealing with the ex that's facing criminal charges. Usually they have to continue to fight and communicate with their ex. And ordinarily, people don't have to do that. Ordinarily, what happens is the criminal court enters something called a no contact order that does not allow the defendant to speak with certain people. Witnesses, for sure, they're not supposed to speak with. But oftentimes, they have some kind of bond, like they're out on bail, or they have some kind of pretrial release conditions. And in those conditions, there are more details, and there's typically something along the lines of that you have to stay out of trouble. So whether there's a no contact order against the other parent, or whether they just have to be good to stay out of jail while they're pending their charges, pending their trial, it's sort of a point of relief. And usually what family courts will do is they just won't allow, okay, so they either won't allow contact or they'll allow supervised contact, and it probably depends on the charges. Like when I see a case with child abuse and neglect, they just won't allow contact at all. But when there's, I guess, petty charges of sorts, they'll typically allow supervised visitation. I haven't seen a single situation where a person had criminal charges pending and they were able to just continue to exercise their custody rights as they ordinarily would, especially if the crime was committed against their ex. And that's one of the things that I've noticed is an issue with these domestic violence cases. So normally, as I mentioned earlier, somebody commits a crime and they're not allowed to communicate with the victims. And then there's these legal principles that I didn't know about that I've heard of recently. For example, if somebody threatens or terrifies a witness into not testifying or testifying falsely, they can add more charges, of course. That's a pretty standard thing. But I also have read case law where the state can actually submit hearsay evidence. They can basically say, hey, this person has a right to confront their accuser. That's a constitutional right, but there's a limit to that right. And if we can show that they are scaring or coercing their accuser, we can just show you some hearsay stuff instead. So that's one of the big things. But with these family court cases, that doesn't happen. And that's because of the person's right to, I guess, have contact with their child. So the ability, from what I've seen in these domestic violence cases, for the defendant to continue to coerce their ex is still there. And I've recorded a few of them, and it does seem to be a really big issue where they're able to use their custodial rights, even if they're supervised visits, they can still at least communicate to sort of just kind of be an ongoing presence, a reminder for the victim. In any other case, they wouldn't be able to do that. But when they share a child with that person, they can. So then there's also complaints from the other side, which is the person that's facing charges. And usually that person is complaining about really long delays in their trial and not being able to see their kids for a really long time, sometimes more than a year. And the only thing that seems to make any sense to me in that situation is for them to not waive their right to a speedy trial. It's like you have two choices: speedy trial, get it resolved, and then either go to jail or resume your contact with your children, or play the long game. And you just won't be able to see your kids for a long time. But I've never seen a person that seems to be accepting that situation. I've seen instead couple of cases that we've recorded on our Nevada judges where both times the defendant complained and continued to file things in their family court case. So they basically stalled their criminal case out for a long, long time, complained about not being able to see their kids, and continued to litigate in family court while their criminal proceedings were pending. Even though this is a video that's mainly opinion, at least it makes you guys aware of a pretty serious issue that I continue to see over and over again. Something that not many people know about. It's a pretty, I don't know if I want to say complicated issue. It's just one of those things that it gets real technical. You don't see the problem unless you understand how it all works technically, both the criminal side and the family court side. So I hope that this video is helpful for some people. A lot of times in these cases, I think so many times parents get their hopes up. They have an ex that is, I guess, according to them, a nightmare. They're now facing criminal charges. They get their hopes up and they think they're finally going to be free of them. But in most of these cases, they just take a deal. They stall the case out for as long as they possibly can, continue to litigate in family court, and then take a deal. I mean, I guess it's different if they can't get out on bail. In Nevada, it's a lot easier to get out on bail now than it used to be before they changed the rules. Maybe in other states you don't have that issue. Maybe in other states they'll end up in pretrial detention, which I'm not going to say is a great thing. In principle, that's a problem. That's one of the reasons why Nevada changed it here. But in those cases where a person's in jail, obviously they don't have to, you're not going to be dealing with them at exchanges and stuff like that. But in the other cases where the person's out pre-trial and they're dragging the case out for a year or two and they're still filing stuff in the child custody case, and you're getting your hopes up like maybe one day it'll be over, it probably won't. They'll probably take a deal at the very end. They'll probably get a probation or suspended sentence on whatever it is that they did. And usually they do what they're called no contest pleas, nolo contendere, I think that's how they say it, and or Alford. And as far as I know, it's not the same as a guilty plea. So like if they take a guilty plea, you can say, hey, look, in family court, you can tell your family court judge this is the crime they committed, even though it wasn't proven at a trial. They took a guilty plea. But when they do these no contest or Alford pleas, it might not be that simple. They may be convicted and they may suffer the consequences of the conviction, but they may be able to say, no, you're going to have to actually prove this in family court. You're not going to just be able to say, I pled this, therefore I did this. So yeah, this is just going to be one of those videos that makes people aware of a pretty convoluted situation that for me seems to be more and more common. And hopefully it's helpful to some people. I have a feeling some people here might have some stories. In fact, that might be helpful. If you've gone through a situation like this, whether you were the one that was facing charges or whether you were the one that had to wait and see what would happen, post down in the comments below. It might be helpful to a lot of people. All that being said, I will see you guys next time.